My name is Michele Ballagh. I'm a lawyer and trademark agent here at Ballagh and Edward in Hamilton. We're located in the McMaster Innovation Park, and today we're going to be talking about trademarks for entrepreneurs, particularly managing trademarks. In Canada, a trademark registration presumptively grants the owner exclusive rights to the trademark in all regions of Canada for the goods and services listed in the registration. An unregistered trademark will only have limited legal protection in the geographic region where it has a reputation. So, for a business that serves only its local market and has no plans to expand, registration of its trademark may be considered unnecessary for most purposes, although there are risks for this strategy. However, any business that serves or plans to serve markets over a broader geographic region in Canada should consider filing trademark applications for its leading brands. Word marks generally enjoy broader protection than design marks, and design marks are the marks that include graphic elements. In addition, word marks are not eligible for protection under copyright law, whereas the graphic elements of a design mark may be eligible for copyright protection. Finally, any modification to the graphic elements of a design mark after its trademark application is filed may render the resulting trademark registration invalid for non-use. For these reasons, the registration of word marks is usually given priority over the registration of design marks or logos. The first priority for registration is usually any trademark that appears in the name of the business. Contrary to the expectations of many business owners, the corporate names and business name registrations that they get upon incorporation do not grant exclusive rights in the name for any geographic region of Canada. A valid business name registration or corporate name does not even grant the business owner the right to use that name in its signage or promotional material. On the other hand, a valid trademark registration is an absolute defense to allegations of trademark infringement and grants the owner the right to prevent competitors from adopting a confusing trademark in Canada. It is always important to remember that a trademark is not the name of your product or service. It is a brand name. It should only be used as an adjective in combination with a generic name for the product or service. You don't want your customers to forget the generic product name. You should not use your trademark as a noun, a verb, or in plural form. For example, it is incorrect to use Oreos to describe Oreo cookies. It is also incorrect to use Xeroxing to describe the activity of photocopying documents on a Xerox copier. Improper use of your trademark as a noun or a verb in your marketing and promotional materials will encourage your customers to believe that it is the name of the product or service. While this may seem beneficial to your business at first, it may ultimately destroy your trademark. If customers forget the generic name of the product or service, your competitors may be entitled to start using your trademark to identify their products. This was the unfortunate fate of the trademark escalator for moving staircases. In promotional material, a trademark should be displayed in capital letters or a bold font and marked with a symbol which identifies it as a trademark, any means by which to set it off from the normal text in your material. The capital R in a circle is the proper notice or marking for a registered trademark. If you have an unregistered trademark, the capital letters TM is how you properly mark those as trademarks. The symbols should be placed adjacent to the trademark, usually in superscript form, and where possible, a legend should appear elsewhere in the promotional material or packaging that identifies the owner of the trademark by its full legal name. You can usually find examples of this on your cereal box when you're eating breakfast in the morning. To the surprise of some, exclusive rights in a trademark can be lost. Even a trademark registration will not preserve the monopoly in a trademark that has been abandoned or is no longer associated with a single business. Proprietary rights in a trademark are maintained through consistent use of the mark in the marketplace by a single business. If your business discontinues a product or service for several years, you may lose your exclusive right to use the trademark for that product or service. If you or your competitors use your trademark in a descriptive fashion, it may become generic, and you cannot exercise a monopoly over a generic term. If you fail to control the quality of the services or products offered by licensed users of your trademark, for example, franchisees, the trademark may become associated with the licensees rather than with your business because there is no common standard. The result is a trademark over which you may no longer be able to exercise a monopoly. For these reasons, businesses are obliged to police the use of their trademarks in the marketplace by other parties. Again, trademarks are familiar to us as consumers, but business owners need to consider trademarks from the other side. Again, a trademark is a form of property. A prudent business owner will take steps to maintain the buildings and land on which his business operates and will not let others build structures that trespass onto his property without his authorization. The same should be true for trademarks.